Well, I take a copy of the trust, and I'm looking for one particular provision in it. It's the accounting provision, but it doesn't always say accounting. If it has no accounting provision, it means the state law created by the legislature applies. The state law was written to limit financial institutions when they act as trustees. I can bust that trust every single time, walking backwards, blindfolded. But if it has an accounting provision, I look to see, does it mirror the state law? If it mirrors the state law, I can bust that trust. But if it doesn't mirror the state law, I now have to think about it, look at it, try to understand it. And if it was written by a Monet lawyer, I can almost never bust that trust because the lawyer knew what he was doing. That's another example of what I mean by comprehensive. Here's another one. Everybody thinks about this one. Almost every will out there has a provision in it called a non-contest provision. So if somebody challenges the will, they don't receive anything. Now, they're not always written right, but that's what they have in it. 80% of trusts have no non-contest provision at all in them. And the ones that do have a non-contest provision in them, it will allow you to win the contest at the end of the contest. But I hope you understand what we've talked about today is you don't want to be in a contest because the contest takes years and costs tens of thousands of dollars to be in that contest. You want a non-contest provision that was written by a Monet lawyer that stops the contest before it begins by sending shivers down the back of any lawyer who's looking at this and doesn't want to do it. This is what we mean by comprehensive. A good Monet trust has between 20 and 30 provisions in there that are comprehensive. Second thing a Monet trust has to have, it has to be administratively simple. So I take a copy of the trust and I'm looking for one particular provision in it. It's the accounting provision, but it doesn't always say accounting.